warm welcome to all of you to the fourth podcast of Writ and Talk. Today we are delighted to have with us Mr. Lalit Panda, a senior resident fellow at the Vidhi Center for Legal Policy. Today we will discuss his paper, The Weight of Secrets, Assessing the Regulatory Burden for Informational Privacy in India. I extend a hearty welcome to you, Mr. Lalit.
Thank you so much, Ms. Basti. I'm very happy to be here.
All right. So, just to give you all a brief context of the topic that we shall take up today. So, in today's world, information technology has deeply impacted our lives in a variety of ways. And hence, it cannot be allowed to remain unregulated. However, considering the growing complexities revolving around digital governance and the handling of data, it has become all the more difficult to efficiently design a regulatory framework designed to protect data. So, this paper that we shall discuss today touches upon the proposals of the Sri Krishna Committee while drawing on the experiences of other jurisdictions. It also justifies the idea of a unified cross-sectorial data protection regulator with a broad mandate and eventually examines the limits of sectoral regulation and clarifies the significance of an outlook for models such as co-regulation and responsive regulation, as well as the role of the much vaunted principle of accountability. So, without further ado, I would move to my first question. So, Mr. Lalit, in your article, you have mentioned that schemes for data protection cannot be ex ante in nature, such as licensing and permissions, because it would eventually result in the throttling of the culture of innovation in the tech industry. So, could you please elaborate on the problems posed by such ex ante regulatory schemes and alternative solutions which can be adopted by the agencies for adequate regulation of information and technology?
Uh, let's lay out a little bit about what ex ante regulation is about. This particular statement that you're quoting from the article, it features as part of a broader background about what we should keep in mind about regulation in India generally and the specific problems about regulation of information technology before getting into questions about um, data protection regulation specifically. So in drawing out this general background, what I was trying to do, and especially when mentioning this aspect of ex ante regulation, was point out that there are certain general issues about regulation in India, as well as regulation of information technology, that are relevant if we want to understand data protection regulation. When it comes to ex ante regulation specifically, we need to first understand what kind of ex ante regulation we're talking about here. Ex ante regulation means, generally speaking, any kind of regulation, any kind of regulatory action that somebody takes, that a regulator takes before any illegality has taken place or before any actual harm has occurred yet. So it is, in a sense, you can think of it as often precautionary or uh, without any actual occurrence of uh, a default of a law. Those kinds of regulatory actions would be ex ante. But specifically, the kind of ex ante regulation that raises many concerns for us uh, is ex ante regulation that comes in the form of licensing and permission. What this means is that before taking certain significant business actions, there might be a requirement under law that the government has to provide an approval or it has to license any such activity. And whenever you give the government this power to to give permissions before any activities take place, it has to be considered very carefully about what the consequences of this are. Number one, if the kinds of actions for which you are requiring government permission are very vast in number, there's a huge volume of them. For example, you want permissions for certain kinds of transactions, then there will be a lot of such transactions. The problem that comes up is that you need state capacity. You need government personnel with adequate skills and knowledge who will be able to apply their mind to these transactions so as to provide the permission. And India has had a long history of low state capacity, which means that in terms of the skills and expertise of our government personnel, as well as in their sheer numbers, in terms of their government personnel to the ratio to the number of citizens, India has performed poorly, which means that we don't have adequate state capacity. So if you keep that in mind, then you would suggest that yes, perhaps ex ante regulation of the in the form of permissions and licensing especially is bad for India. And secondly, the other problem is that when you have a system of licensing, the kinds of problem that the government officer who has to license your activities causes is that this government officer now gets the discretion somewhat to not just approve or reject your license or your permission on the basis of some lawful or legitimate reason, but also for some extraneous reason. This could be, pure favoritism for your competitor. It could be outright corruption. It could be some form of discrimination. All of these things could be, extraneous reasons why licensing could be used by the government officer in an illicit way. So both of these concerns, you'll realize individuals who lived in India in the period pre-liberalization, pre-liberalization in the early 1990s, they had to deal with this in all forms of industries and sectors, opening some kind of factory, engaging in certain kinds of manufacturing of certain products, employing certain kinds of people. For all of these things, business persons had to get permission before they could even start doing them. So when somebody makes a form of business plan, when somebody has to meet competition in a particular way by moving fast or innovating or doing some action that responds to the market situation, all of those immediate responses would be shackled by this possibility that you have to wait for the government officer to approve what you are doing. And imagine all of these things, all of these problems that limit business activity when it comes to ex ante regulation like licensing. These are multiplied manifold when it comes to information technology. Why? When it comes to state capacity, already you can see that information technology issues give rise to a vast volume of information flows. There is high speed information flows, there's high speed of innovation and change in technologies, and there's just a lot of uh, volume of transactions that are taking place that need to be regulated. So on that ground, you would need a lot of state capacity to be able to deal with permissions and licensing for such kind of activities. And secondly, even if we consider that there is such state capacity available, the fact remains that requiring permissions will slow down various activities. As you asked in your question, it does have an impact on innovation. And this is relevant for us when we think about regulation of technology, because the regulation of information technology has greatly transformed, has vastly transformed our lives in the last few decades. And arguably, it has transformed our lives for the better because we have we have welcomed it with open arms. A large range of the changes that we see in our everyday lives, in the ways we interact with each other, in the way we obtain knowledge, in the way we entertain ourselves, in the way we conduct our everyday activities, are now undergirded by information technology, the way we use it. And this is the fruit directly of innovation in the technology industry. So not only is it very helpful for us, it has been very fruitful for us to allow this innovation to take place and not be stifled. But also, so far as India is concerned, this innovation is now characterizing global competition in the technology industry. So any change when it comes to the pace of innovation would be difficult for any one country to do on its own without suffering economically or in terms of competition. And this is a relevant factor to keep in mind when trying to design a regulatory system. So I hope this makes clear somewhat as to why ex ante regulations like licensing are a problem. Generally speaking, that's not to say that you can't have any ex ante regulation in data protection at all. There are some areas in which you do have it. You have it in, say, the regulation of or the standard setting and approval of data protection officers who are these professionals who engage in who internally regulate uh, various bodies that are using data, personal data. We also need ex ante regulation, for instance, when it comes to certain risky activities, like certain kinds of emerging technologies or cross border data flows. Uh, Various data protection laws have ex ante regulation in the form of approving your group scheme or your standard contracts on the basis of which these cross border data flows are taking place. So yes, you have some narrow areas where ex ante regulation will still be taking some role, but the bulk of the regulatory approach for data protection is nonetheless ex post. There might be some oversight and monitoring, which is you can consider that also ex ante, but the bulk of the regulatory response is in the form of ex post responses and that form of regulation. So my, I mean, summary to sum it up, essentially licensing permissions seems a pretty bad idea when it comes to data protection regulation. But there might be some places where ex ante regulation might still be useful, and mostly it should still be ex post.
All right. So we move on to the next question, which says that the responsive regulation model that you have proposed in this article, it faces the primary challenge of being inherently reactive. So this means that the action is taken only after a problem or a violation has occurred. Now, this might lead to a situation where individuals and businesses are not incentivized to proactively address the data privacy concerns, as they may only face consequences after a violation has occurred. So, do you think that this is a valid concern? And if so, how do you propose to address the same?
That's actually a very well noticed issue. Let me just unpack that a little bit in a couple of steps. First, let's just be clear about what we mean when we talk about responsive regulation. Responsive regulation is this principle that was developed to explain a particular way in which enforcement tools should be used by the regulator. What do we mean by enforcement tools? We mean all the forms of regulatory action that ensure that legal rules are actually complied with, that there is no violation taking place. All of these enforcement tools, they could be outright enforcement tools like penalties and criminal prosecution. There could be much lighter forms of enforcement tools like simply naming and shaming a company with a public report, or there could be just uh, requiring them to provide information to you. All of these things are various ways where the regulator can nudge the regulated entity into complying with the legal provisions. Now, what responsive regulation does is that it says that how you apply, what kind of enforcement tool you apply, and what level of intervention you have with a regulated entity, the scale of that intervention, the punitive effect of that intervention, all of these things should depend on the nature of the conduct or the default. Which means that if it is a one-time default, if it's an inadvertent default, then you can have a lighter approach to it. And if there is a more serious default that is intentional and it's happened many times, then you can escalate on a sliding scale, or like in a pyramid. You have a range of enforcement tools. You choose the more serious enforcement tools as the seriousness and the gravity of the default increases. Now, this should clarify that this form of thinking about how you should respond to illegalities or default or harmful behavior by regulator activity, this clearly seems to have a link with how we think about proportionality of penalties. For example, you have a more strict punishment for a worse offense, and you have a lighter punishment for a less light offense. But the way you need to think about this when it comes to regulation is that it's thinking about this over multiple defaults. So you can escalate and de-escalate your responses according to um, uh, the change in the behavior of the regulated entity over time, which means if it is responding to what you're doing, you change your behavior up and uh, you can lighten the response. And if it does not respond to what you're doing, then you can increase it. So this kind of fairness of proportionality and the consistency that this brings to regulation, that's one of the core benefits that it's supposed to provide. It's supposed to be a little more predictable. It's supposed to create a credible threat of sanctions, so that a regulated entity can tell that, hey, I have already committed this particular default once. If I am committing that default again, I am going to get a harsher punishment, and I can be sure of this. So these are the sort of general principles that responsive regulation is supposed to provide for. Why it is especially useful in the Indian context and why it's worth stressing this benefit of responsive regulation is that it allows for prioritization and it allows for the allocation of scarce regulatory resources. As I mentioned already, we do have a problem of state capacity. And even apart from the question of state capacity, the fact still remains that data protection, along with information technology generally, but data protection particularly, is a complex it's a complex field with a lot of contextual questions involved, with a lot of opacity of the transactions and data flows that are taking place. It is very difficult to actually go out of your way to investigate, check on, and enforce in all areas. So you need some method by which to, save up on your regulatory resources and apply it where it is really needed most. That's what responsive regulation is supposed to do. That said, the criticism that you're referring to, that it is mainly reactive and it does not actually go out of its way to prevent something from happening, that it only reacts to defaults, this is actually correct. Uh, so this is a problem because, as I mentioned, there is a lot of opacity in the way in which personal data is used. And because there is so much opacity, you can't just be reacting to things when the default takes place. You need to proactively go out of your way and find out where such defaults or illegalities or harmful activities might be taking place in the future. So you need to proactively monitor the industry. You need to engage in information gathering and research into these cutting edge fields of technology beforehand, before the actual harm takes place. And so then you can take precautionary steps. You can take steps like new rules, or you can take steps like, passing injunctions or directions to prevent certain actions from taking place that might end up being harmful. So that said, though, even though we accept that this criticism of responsive regulation exists, it doesn't remove the significance of responsive regulation. Why? Because we just have to understand that this principle or this system has been proposed as a way to guide regulators in the use of enforcement tools as responses to defaults or harm, or even you could say risks. So this idea of a sliding scale or a hierarchy, or the idea that you should respond in a way that takes account of the existing conduct and doesn't, treat the existing conduct of that entity as irrelevant, but accounts for it. This is applicable even if we are separately engaging in monitoring and oversight. So you can be doing proactive and reactive forms of regulation at the same time. This is what I would suggest, that while what you're saying is correct, uh, Ms. Bagchi, that responsive regulation on its own is only reactive, this doesn't mean that we stop using responsive regulation. Instead, we can supplement it with other proactive steps.
All right. So we move on to the next question. So, Mr. Lalit, in your paper, you have suggested a co regulatory model where private and public agencies work in tandem. Now, this model would entail state regulation, including the approval and oversight of non state actors as well. So, the question that I would like to ask you is that what would the division of powers be in this model, and to what extent will the private players be allowed to engage in this process? Moreover, what do you think will be the impact on a rights based model of data protection and regulation if non state actors are engaged in this particular process?
All right. Yes. So I guess so. You've asked me two questions. Before I can get into them, let me just lay out how co-regulatory models of governance of regulation, uh, how they actually match up with others. I think the form of regulation uh, that we're most familiar with is what is called the command and control form of regulation. In the sense that in this form of regulation, the regulator, basically the government, tells the regulated entity what to do. It has to decide beforehand that the regulated entity has to engage in XYZ activities, or cannot engage in XYZ ABC activities. It formulates the rules through an internal process of deliberation that may not involve the regulated entity at all. And in the enforcement of these rules, it does not in any way um, use the assistance of uh, the regulated entity. So that's what we understand normally by regulation, that the government is regulating a regulated entity. And on the other hand, we have self-regulatory entities, self-regulatory model, where the regulated entities, like, for example, the most famous form of self-regulation is journalism, where journalists set standards for themselves, and there are internal systems of censure and systems of network where punishments happen internally within a profession, uh, which is regulating itself. We understand these two as the two opposite poles of regulatory model. The co-regulatory model is supposed to be some kind of fusion of these. And you've asked me how exactly we are supposed to divide, I guess, divide this cooperation between the public and the private entities that are engaging in this co-regulatory model. At what at what stage does the government stop doing something and the private entity involve itself in regulation itself in the regulatory system? So to understand where that division takes place, I guess it's good to just go through some of the forms of co-regulatory tools that exist. So I guess a good example would be from certain good examples would come from data protection itself. For instance, there is the most famous form of co-regulatory tools is what is called the code of practice. Now, a code of practice is basically a form of more detailed rules, you could say, uh, that are not they're not rules in the sense that if you do not comply with the rules, you suffer from a penalty. Instead, these codes of practice are specific rules that are created that act as safe harbors. What is this supposed to do? Basically, let's take an example that let's say this is about data storage. Now, data storage rules in the actual statute, the general statute, they often say something like this, that data storage should be for such a period, for only such period as is necessary for the object, for the purpose specified for that particular processing activity. So you only store the data for as long as is necessary for your purpose of processing. Now that sounds very vague. What does this mean? How much is necessary? And the problem is how much is necessary changes from sector to sector and changes from context to context. And for these specific contexts, you need to create these codes of practices where what does the code of practice do? The code of practice essentially serves as a rule that if you comply with the code of practice, this serves as evidence that you have complied with the law. It's not automatically the case that you have been found to comply with the law. You might still be found to be having committed an illegality, but it is evidence of the fact that you might have complied with the law. So, prima facie, if you comply with the code of practice, you can be said to be safe. But some further evidence might come out to suggest that you are actually uh, um, in violation of the law. That might be the case. So, the way this is a regulatory tool is that these codes of practice are actually developed in cooperation, which means that while industry players might provide inputs to the government or the regulator, or they might actually even draft the code of practice themselves on the basis of their expertise and their knowledge about how the specific activity is taking place in the sector, the final approval of that code is done by the government after vetting. And the government can decide to reject it or it can decide to change it up but it is made in cooperation with each other. It's somewhat like saying that regulations are being drafted in cooperation with the regulated entity. So that's what we do, except that it's not an absolute regulation. It is just only an evidentiary safe harbor. That's one example of a co-regulatory tool. There are many others. For example, even a complaints redressal model that you have inside an organization. If there is a complaints redressal model inside, let's say Google, and you say that I'm complaining to Google about the fact that Google has violated its own privacy policy, then in a way, privacy is being enforced by the regulated entity itself when it is dealing with your complaint. So, to the extent that these complaints redressal models are mandated by law, this is how the government is requiring the private entity to support it in doing the regulation. So that's another one. There are various other forms of co-regulation, co-regulatory tools. Professionals are created like data protection officers. These are officers who are the employed by the regulated entity, the data fiduciary or the data controller, as it is called in EU. They employ these people, and these people are made responsible. The data protection officers are made responsible for the compliance of that company with the data protection laws, generally speaking. So here you have an officer, a private officer, who has been mandated with the duty of enforcing, in a way, or complying with the law. So all of these tools are ways in which the law is trying to shift some of the burden of ensuring that data protection is uh, adequately from the regulator to the regulated entity or to certain players in the regulated entity system, in the system that is being regulated. So there could be even professionals who are outside of these of the regulated entity itself. For example, there could be external data auditors. You have these auditors who come to audit your financial documents and stuff like that. Similarly, you can have external data auditors who come in to audit your data protection practices. And these are systems by which you can ensure that even though there is a huge and heavy burden that is placed on a data protection regulator, there are people in the private sector who are assisting it and who are helping it along the way. Now, so far as this system, where you take the assistance of private actors, non-state actors, in implementing data protection, insofar as this system is taking place within data protection, you are correct to raise the question that how does this affect the fact that data protection is a right-based field? The data protection is a right in itself, and it is supposed to involve the right to information and privacy. How is that being safeguarded adequately if non-state actors are actually responsible for enforcing it? I think that in principle, per se, there is nothing to suggest that non-state actors, private actors cannot, under law, be made responsible for the protection of rights. It's not something that on its own seems wrong. What's important is to make sure that the right isn't lost, or the right isn't violated, or there is inadequate protection of the right because these regulated entities are biased in favor of themselves. And how does that happen? That happens as long as you ensure that there is adequate oversight over these regulated entities, so that if they are not engaging in their co-regulatory step in, there has to be a system of appeals, such that if any user or any citizen is not happy with how the co-regulatory activity is taking place, for example, in your internal redressal, complaints redressal mechanism, that has not happened very well, you should just be able to appeal from it to the regulator. That right must be available. And lastly, a co-regulatory activity, especially such as activities like creating codes of practices, they will only be successful if you ensure that there is transparency in the system by which those codes of practices are created. So yes, there are some risks with co-regulation, but there are safeguards that can be put in place to ensure that these risks are counteracted. And what's important is that we gauge, or we at least measure appropriately how far these co-regulatory tools are necessary because of the vastness of the burden of data protection as a regulatory field. There's just a lot of work that a data protection regulator will have to do because of how many things and how many ways personal data is used. And that is why this sort of a thing might become necessary.
So the next question is about the application of the solutions that you have proposed in this paper. So the regulatory environment for data privacy in India is complex, with multiple overlapping regulations and guidelines. And there is a lack of clarity around the scope and application of the right to privacy in the digital age. Now, this creates a lot of uncertainty around the legality of certain data processing activities. And additionally, the regulatory framework for data privacy in India is still evolving, which can make it difficult for individuals and businesses to understand their rights and obligations. So, in this context, do you think that these issues could be a challenge in the way of applying the solutions that you've proposed in this paper? And how do you think the data privacy regime can be improved in regard to the same?
Yeah, well, interesting. The factors that you're referring to, the fact that the actual scope of a violation of data privacy and the inchoate nature of Indian data privacy regime right now, all of these things actually are arguments in favor of adopting the principles that I have proposed. Uh, for one thing, this is something we didn't really discuss, but I've actually pointed out in the uh, you actually pointed out when you described the subject matter of the paper itself. The proposal is for a unified cross-sectoral regulator. Now, given the fact that India's data protection regime currently is not set up properly, what we actually have is various different sectoral regulators who are trying to do a little bit of data protection on the side. So you see that there is some data protection happening from TRAI, there is some data protection happening from RBI, and many of these different sectoral regulators can come up with their own rules regarding privacy. But this is a big problem, as I try to point out. Sectoral regulation is not the way to go when it comes to data protection. Not only is data protection a fundamental right in the sense that it requires some minimum baseline that everybody is able to follow, but if you have sectoral regulators, you don't account for two very important phenomena when it comes to data flows. One is that data flows across sectors from one sector to the other. And there are even companies that are cross-sectoral because they have horizontal width across different industries. So all of this cannot be accounted for by one particular regulator from one particular sector. They have to make sure that that data that is going out of one sector and going elsewhere is not still causing harm. And even if you have a number of sectoral regulators, there will still be a number of sectors where there is no sectoral regulator at all. What's going to happen about data protection in those particular areas? So this is one very simple example of how the existing situation in India actually would provide an argument in favor of some of these aspects of regulatory design that I'm referring to. And insofar as the other principles I've suggested, such as co-regulation and responsive regulation, you'll find that both of them are actually very, that are particularly useful when we're dealing with a field of law and a field of law that is conceptually having more ambiguities and a field of law that has not yet developed to the maturity that it has clear allocation of rights and duties. How is that so? For example, a co-regulatory scheme, the example that I had mentioned earlier of codes of practices uh, and such tools, what they do is they take the general principles of a statute, which many might consider to be ambiguous and vague, and they try to give them specific content through a cooperative system, a networked form of regulation with the regulated entity. And it is difficult to arrive at these crystallized forms of rules that are applicable in each sector without a good understanding from the players in that sector itself as to how it should be operating. So co-regulation is very much useful. in a situation of regulatory uncertainty. And responsive regulation is equally a response, a solution to that regulatory uncertainty or compliance uncertainty. Because, as I mentioned, a responsive regulation principle requires you to deal with first time offenses, first time defaults, inadvertent defaults that do not seem to have the markings of something that is, was intentionally meant to cause harm. You can deal with that with a lighter touch, and then you can escalate the enforcement tool gravity according to the gravity of the default that is taking place. So these principles that I'm referring to in this paper are actually quite useful when we deal with a situation where the field of law and the stage of development of the law create uncertainty regarding rights and duties.
In the paper, you've highlighted the lessons that India can adopt from the success of other jurisdictions when it comes to the implementation of their data privacy laws. Now, I'm curious to know if there's a specific way in which the failures of other countries can also guide us in this particular respect.
All right, so that's actually in a way that's actually a difficult question to answer because the people who view data protection law and data protection regulation today, they actually come from various very different and divergent points of view about how it should be like right now. So even if I say, or even if somebody says that a particular country is failing in its data protection regulation in some way or the other, there is somebody else who does seem to have the view that they are not failing and they're actually doing the right thing. And you'll see this perhaps in the most stark sense in the binary that is supposedly existent between EU and US. So the US has largely taken on a form of sectoral light touch regulation that is largely self-regulatory almost, whereas the EU has taken on a form of regulation uh, um, which rests on the idea of a unified data protection regulator for each country, and it does not at all engage in any form of self-regulation. It's mostly a command and control with some co-regulatory features that is involved in that. But there are people who say that the US might be failing when it comes to the protection of the slow erosion of informational privacy in that country, while it is succeeding very well when it comes to innovation, information technology innovation. And there are those who argue that the EU is taking the forefront when it comes to the protection of rights, but it is actually hampering innovation and growth of the industry, of the technology industry in its respective states. Uh, so, in this sense, it's very difficult to say what's going on. But one thing that has to be noted is that insofar as the data protection laws that are being adopted in other countries, slowly there is a trend that does seem to adopt the EU model or EU adjacent models or EU inspired models in various countries, while the US seems to be increasingly left behind as an outlier. It's all alone as one of the countries which seems to not be doing a similar form of regulation. Though there have been calls inside the US since a long time, they've not managed to create a proper data protection, unified data protection law for their country. There's uh, some in California and some other specific sectoral laws, but otherwise it's not the same. It doesn't have the same teeth and the strength as what you have in the EU. So yes, there is something to learn from the US in this sense. The failure of the US to bring in strong data protection law, I would think, is a decided failure because they are taking advantage of the fact that other countries are bringing in data protection laws to allow for their own economic advantage in the field of information technology. Perhaps if they brought in if they brought in data protection laws, some other country would, take advantage of that and say that we will have looser data protection laws. So why don't all the tech companies come and work out of our country? Now, this seems to suggest that any country that actually fails to create adequate data protection laws is contributing to a global um, reduction in the standards of informational privacy. And I think that's the kind of failure that we should focus on and something that we should not be engaging in. A pragmatic view would be that we should wait for a global consensus to develop before jumping in all the way like the EU has. But arriving at that consensus requires us to sacrifice a little bit and push in that direction, or at least appear to be interested in creating that kind of a world where where the rights that we have to our own personal data matter. So that's the kind of failure I think that's worth pointing out.
All right. So, Mr. Lalit, in light of the rapid uh, use of artificial intelligence and the rise of big data, we've seen that there have been a number of ways through which our lives have been impacted. Now, how do you think that these recent developments uh, affect the landscape of informational privacy in India?
Well, the way in which emerging technologies are actually affecting informational privacy is not unique in any way in India. It's perhaps happening in a very similar manner in all across the world, but at perhaps different paces, because it might not be as deeply penetrating all our technological aspects, all our technological uses right now. But I can give you a conceptual view about what's happening with these emerging technologies um, in the sense of two core principles that data protection seems to envisage. One is called purpose specification. Now, this is a substantive data protection principle which suggests that if we want to reduce the amount of harm that might be caused by people using your data, we can reduce how much data somebody is taking from you, and we can require by law that if somebody is taking some data from you, they should only use it for the use that they specified, the purpose that they specified. So this purpose specification that is required to limit both the amount of collection of the data and what that data is used for, that purpose specification runs counter to some of these emerging technologies and the way they work. Artificial intelligence and big data often operate in a way where the purpose of the usage of that data isn't fixed and narrow from beforehand. That means that for various kinds of big data analyses in which different forms of data set, vast data sets are uh, um, uh, brought together, aggregated, and connections are found, those connections between different forms of personal data are not found by specifying the purpose beforehand. They allow room for accident and for organic growth of that discovery as one of the underlying ways in which big data is successful. Similarly, artificial intelligence may have a range of algorithms that are constraining it, but these algorithms are having so many variables and so many different uh, uh, specific rules that are embedded in it that it is no any one purpose. The artificial intelligence verges on a mind that has multiple purposes and objectives in its mind. So there's no purpose specification happening in either of these areas. Uh, Similarly, another principle of data protection that is under jeopardy is the question of data sensitivity. So, data sensitivity is the idea that there are certain categories of data which are more sensitive, that are more likely or more capable of causing a violation of your privacy than other categories of data. For example, your name may not be as sensitive as the fact that you have some health issue, or that you are of a particular political affiliation. These are sensitive categories of data that you may not want to disclose to everybody and anybody. They can cause harm to your dignity. They can cause harm to your liberty in a political scenario. All of these questions are dealt with by data protection law by saying that we should have some stricter rules in relation with sensitive personal data. Now, people are suggesting that in the age of big data and in the age of inferring different forms of data out of other categories of data, uh, inferring certain data out of certain other categories of data, actually you can infer all kinds of data out of some similar category or some adjacent category of data. One example, for instance, is how you can infer what religion somebody is from by checking their dietary preference. So Zomato might have an idea about what your religion might be. Maybe it will be able to tell in certain instances. So people are arguing then that we should not use data sensitivity. We should instead be referring to the kind of use, the the category of use that the data is being put to. So Zomato doesn't want to know, and Zomato's purpose of processing your dietary data is not to get to know your religion or do anything about your religion. It just wants to send you what food it wants to send you. So the argument then that's coming then is that these old principles like purpose specification and data sensitivity, these principles should be left behind, and we should move to a model of data protection which is actually dealing only with harm instead of sensitivity and purpose. Uh, that's the way in which these emerging technologies, I think, are having an effect on data protection now.
All right. Thank you so much, Mr. Lalit. So I move on to the last question. So technically, I think this is the last question which has a direct bearing on the arguments that you have advanced in your paper. So, what strategies can be adopted, in your view, to balance the demands of the co-regulatory and responsive regulation models to ensure effective and comprehensive data privacy regulation?
All right. So I feel that the question seems to assume that there is something about co-regulation that is in conflict with responsive regulation. That's why we need some balancing between the two. But I'm not, I think I also try to point this out in the paper that I don't think that there is anything incompatible about those two forms of regulation, which means that uh, you can very much have a form of responsive regulation that has co-regulatory features in it. So I don't think I don't think that is something that we have to do specifically to get these two models to be balanced with each other. Perhaps there are aspects of responsive regulation that require the regulator to take action against defaulting entities, and an adequately proportionate responsive regulatory action may be hampered if co-regulation comes in the way and it does not permit that from happening. But I think I had mentioned this when we were talking about co-regulation. Uh, Whenever some co-regulatory tool, such as internal complaints redressal or data protection officer, or one of these co-regulatory aspects, whenever one of these things is not operating properly, there is nothing stopping the regulator from intervening and taking action against uh, the regulated entity that is failing in its duties. So that response of the regulator, that enforcement action of the regulator can very much be along the lines of the principle of responsive regulation, and that can coexist with co-regulation at the same time. So I don't see much work that we have to do to get them to balance.
All right. So I think with regard to the paper here, we will end the questions that we had. But Mr. Lalit, would you mind if we have a couple of more questions for you?
Yeah, yeah, no worries. Yes, yes,
Okay,
for sure.
okay. So the first question that I have is that we've seen that in the information and technology jurisprudence, it's pretty much upcoming, and it has evolved to a great extent. And there are many students, I mean, the law students and young lawyers, academicians, they all are taking an active interest in this particular area. So, what are the further readings that you would suggest for this particular area of law?
I guess the way we can, one good way, the uh, the problem that I have at least faced when I've been looking at data protection as a field, as a subject matter, is that we don't have, I'm not able to find at least so far, and I've not had to deal with it for some period recently, so I've not looked at any recent publications, but there's no good treatise or one consolidated book or something like that, which gives you a good idea about the legal aspects of data protection from all the aspects of it. So I have actually been picking up about data protection mostly from uh, journal articles, and many of these journal articles are quite comprehensive about the subjects that they pick up. So those journal articles have been very useful. But before we talk about the authors who probably give these articles, who've written these articles, I guess one source that you can rely on is the broader the broader literature that has developed around the GDPR. So there are some books I know that are out there. I have not read them myself, but there are various policy documents, including the papers that are released by the Article 29 Working Party. This is the body that was created to provide guidance on data protection law to the various member states of the EU. So the Article 29 Working Party has various small and accessible papers that explain different aspects of data protection, like purpose specification or consent or all of these different aspects, these different small subjects. The Article 29 Working Party has released little papers about all of these, and those papers are quite authoritative about what those topics are about and how one should think about those topics. So that gives a great view about European law on the subject. Um, at the same time, one book that I can think of, which is pretty useful, is by this author called Graham Greenleaf. He's from an Australian university, and he has written actually by compiling his analyses of various Asian data privacy laws. So the book is called Asian Data Privacy Laws, and it compiles uh, a study. Each chapter is a study. Each chapter of that book is a study of a different country in Asia, and the data protection laws that that country has set up so far. So that actually gives a great snapshot of how things might end up being in India, because after the latest bill in 2022, it seems India is moving towards a model which isn't exactly in the European model, but is closer to these Asian models of data protection. So it will be good to actually study what these Asian countries have been doing in their data protection laws, and how somebody has studied it, and what they have commented about it. I think that's a good book as well. Otherwise, when journal articles, I would reading the articles of Daniel Solove. Uh, the surname is spelled Solove. Right from the basics of what privacy means up to specific questions of data sensitivity and consent, especially. Um, Professor Solove has written a lot of very insightful articles. So these might be very helpful.
Thank you so much, Mr. Lalit. So, coming to the last question, which I'm sure all our listeners would be very interested in, and that is, as and when we've read the paper, we felt that the structure of the article is extremely commendable, and specifically when we look at the intergovernmental comparative analysis being integrated throughout the text instead of a particular section being dedicated to it. So I have a specific query that from where did you draw the incentive to write something of this sort? And specifically, is there any, I mean, advice or any tips for those students who intend to write in this particular direction?
Thank you so much. That's very kind of you to say so. And I guess the one thing that you have picked up as a good aspect of the paper, maybe that's all right. But it has been 4 years since I wrote this paper, and when I reread it, I realized that maybe I would not have written it in the exact same way. For instance, I think one of the things that I now value as a good research article is one that puts front and center right at the beginning what the importance of that topic and what the immediate stakes are, in a way that actually pulls in the reader right from the outset. And I'm not sure I did that very well in this article. But that's something that anybody who's writing a paper should really look out to make clear. Because writing a paper is a big investment in the sense that you spend a lot of time on that subject. You end up reading, you end up writing and rewriting and editing and citing and having to go back to your sources to check that exact source of citation. And it can be very taxing. So one really wants that that paper is, doesn't just fly around and is actually read by somebody, which makes me very grateful that somebody has actually picked up this one to look at it. But what I'm trying to say is that if one wants this, one has to take a little effort in trying to make the paper accessible and trying to give the reader a promise right at the beginning that you are going to tell them something that they will find useful. And if you give that promise, that hook in the beginning, that here you need to read this paper, this is a paper that is going to tell you something that you need to know, then that's a good thing to keep in mind. As for the actual structure of the paper, the rest of the paper itself, the way in which one has to go about that can change from subject to subject, and it's difficult to offer any one kind of stylistic rule about how one should do it. For example, I could sequence the different topics in the paper in a different way. But when sequencing it in a particular way, you have to think about how it is building up. You have to think about whether you should put the important subjects first or you should put the less important subjects in the beginning and it builds up to the most important one, because logically that might be necessary before they understand the more important topic. These sorts of things can not only be a question of logic but also about rhythm and style, about what's the effect that you want to have on a reader when they read that paper. Um, and it's just about how good argumentation works, I guess, that you have to pay attention to how this form of sequencing, how you style sentences, has an effect on uh, what the reader is feeling. But I'm sorry, otherwise I don't have any very helpful tip, I'm afraid.
All right. Thank you so much, Mr. Lalit, for those insightful words. And I'm sure all our listeners have enjoyed the conversation we had today. So we are looking forward to host you on campus someday, and lots of good wishes to you. So with this, we come to an end of the session.
Thank you so much. I've been honored to have been part of this.
Thank you. Thank you so much, everyone.